John Gosturani and the Secretary of State for the House of Commons?
Yes, Mr. Lambs.
Lord, I'm here for the appellant and my own friend Colin Toman appears
Yes.
for the Secretary of State. I hope that you have the authorities.
Yes, thank you very much for your extremely helpful documents. I think the papers have been put together pretty well, so thank you for that. So we've had thorough skeletons. We hope we're listed for a day. But well, we don't think we should. It will take as long as a day. Have you had a chance to discuss with Mr. Tom and how you're going to divide your time and what you think about the time estimate?
Well, I was planning to do an hour or out to 2 hours in my submissions. It may be that I don't need that, but my own friend hasn't given me a precise. I think it depends on how much
let's see how we go
need to deal with questions.
I think your client. I refer your client's in court.
Sorry,
your client's in court.
Yes.
Yes.
Yes. Yes, and the bundle is in two parts, A and B. So, but although the skeletons say A, B, I'll just refer to part.
Well, now I've got the skeletons in C.
Sorry, C is the skeletons. There should also have been the updated, perfected skeletons, which have been cross-referred to the bundles.
Yes.
And I hope.
I think we've got all that, but let's see how we go. I've got one with perfected written on. That's yours.
Yes, and I think my own friend also had submitted.
Right.
Yes. So the issue in the case is set out in the permission ground 1, and it's whether the public interest, and that's at part B 1 to 3, and it's paragraph 3 at the bottom of that page.
Yeah.
And it's whether the public interest in deporting a person who commits a serious offence abroad is to be given the same weight as deporting a foreign criminal as defined by the Nationality, Immigration, Asylum Act 2002 as amended by the 2014 Immigration Act. So a foreign criminal, importantly, is, for our purposes, defined as a person who is convicted of an offence in the UK and sentenced to 12 months or more. There are different gradations of seriousness,
yes,
but that's the general point. And the UT did not accept that there was a difference. The UT, and it's at paragraph 26 to 27, says that there isn't a difference in the test. And I just, one brings up that, I'll come back to it, but it's just, it's at paragraph 27.
Yes, well, what? Yes.
It's at the top.
26. 26 you put forward a proposition.
Yeah.
With which the judge disagrees.
Disagree, and he says in terms, I disagree.
He did.
And I think it's pretty stark what the issue is. I'll come to the way he structures it in due course, but it's critically, it's the issue is do you attribute the same weight to the public interest or not?
Well, do you disagree with the proposition in the second sentence of paragraph 27? We're on page 48. So paragraph 27. Although the UK Borders Act 2007 and the 2002 Act define the term foreign criminal in such a way that it only includes convictions in the UK, it does not follow from this that there is a reduced public interest in removing a person convicted of a crime outside the UK.
Yeah, that is what is in issue. we say there is a reduced public interest in removing a person who was convicted of a crime outside the UK. That's precisely the point, and I think that is the point that goes directly to the single ground on which permission has been granted.
And would it follow from that that if you're wrong about that, that would be the end of the appeal?
Yes, that's the only.
So that is
the only issue.
Okay, thank you.
I've got 6. I'm going to look at the facts briefly and then the legislative background, but I've got really 6 points, if I may. The first is that there were 2 legislative interventions, and this is the UK Borders Act and the 2002 Act, as amended, that concerned the deportation of foreign criminals as defined, and by that I mean those who committed those offences in the UK. And the second point is that it's common ground that the statutory definitions of foreign criminals do not relate to convictions outside the UK, and that nor do the immigration rules on deportation, nor do they concern convictions abroad. Convictions abroad, there's a Secretary of State's policy, you can see it, or commentary on the rules, I think it's tab 31. They say, well, it's outside the rules. If it's a conviction abroad, it's outside the rules. Okay. The third point, the effect of those interventions was to create a differential. Otherwise, the interventions, that's the 2 acts, would have been meaningless. And it meant that it means that very great weight is accorded to the public interest in the foreign criminal cases. Further, as we've come to see, the 2002 Act goes a step further, and it actually guides, or governs rather than guides, it governs how a tribunal is to determine the Article 8 issues. It's not advisory, it's mandatory. So that's part of my third point. If Parliament had intended the same weight to apply in the appellant's case, it could simply have said so. It could simply have said, included in the definition, overseas convictions. And the fact that it didn't really has to be respected.
But it couldn't have said that because it does it by a reference to the length of imprisonment. And we don't know that other countries are imposing sentences that indicate the same degree of gravity. We might get a 6-year sentence of parking on double yellow line,
Yes.
frivolously, whether you only get a fine here. So it couldn't have done that, simply defined foreign criminals to include those who commit an offence abroad.
Well, I would submit that it could have laid down that as a statutory rule, and there is the flexibility under Part 5A. It's 117C bracket 6. I'll come to it. To take into account all the circumstances that pertain to a conviction. So there were particular circumstances that were made out in relation to a particular conviction abroad. Then, of course, that could be factored in, and the statutory scheme allows that.
Well, we're going to come to the...
You're going to come to that.
You're helpful in setting out your proposition. I think you've got to 3, have you? Or
Sorry?
but that, you was giving me 6 propositions.
Yes, I'm
I'm
at 3.
Yes. Parliament intended the same way.
Yes, if Parliament
said
had
so and didn't.
intended, it could have said so, and we've got to respect the fact it didn't. So 4, the upper tribunal rejected the submission that there was a difference in the weight, and we've already really looked at that. And as a result of that, the test was too high, that was applied. The upper tribunal applied a test that was too high. The fifth point is that the error is material because, in effect, the upper tribunal says, well, this is a finely balanced case because there are very strong considerations on either side, even taking into account the high test, the wrongly high test. And those factors concern the best interests of the children,
Yes.
the length of time since the index offence, the lack of repetition for that type of offence, and the fact that family life had been long established in the UK. And I'll come to those. But the sixth point is that we say that the Secretary of State's submissions in relation to suitability and general grounds of refusal that are set out in my learned friend's skeleton are not on point with respect because, if you like, all paths lead back to the mandatory test because all of those suitability provisions are all subject to is it compatible with human rights, which is precisely.
So what do you say is the correct proposition? How should the upper tribunal judge have formulated the test?
Well, I apologise if I seem to, and I think it's not the reasonable test of 117(6), 117(b)(6),
Okay.
Because that's really a concession, if you like, if you've got to.
That only applies if a person is not liable to deportation, and by definition, your client is liable.
Precisely so. But that provision says that if you satisfy that rule, then there isn't a public interest. So it's like a concessionary point.
Okay.
What I'm saying, though, to answer my Lord's point directly, as I put it, I think, in the upper tribunal, an unvarnished and direct application of a balancing test, and it's what Mr. Justice Waxman, I think, who dealt with the CART judicial review proceedings.
Yes.
It's like a balance sheet.
Well, can I understand what that means? So you put into the balance sheet the factors for extradition, the fact that he lied for 20 years about his immigration status.
Yeah.
And you put into account the fact that he has committed a serious offence against women abroad.
Yes.
But you have to remember that the public interest is less than if he'd committed that offence against women in England or Wales.
Yeah, well, I say that it's a question of the weight that you give to that overseas.
But what weight is the maximum that can be accorded to the fact that you committed offences on women in Italy rather than offences on women in England?
I mean, it would be obviously the more serious the offence in Italy, the more weight you would put on it. But the point that I make is that this is if you like, an unvarnished or open-textured balance sheet. And the difference between that and what was actually carried out by the upper tribunal is very significant.
Okay, so just
so that's my
instead
sixth point.
Instead of the offence, if committed in this country, being treated in the way that the statute requires it to be treated, you say it's treated in a wholly different way, in what you're calling an unvarnished way.
Well,
so what does that in fact involve?
Well,
looking at the offence?
It involves looking. I mean, for instance, when you're looking at Bultif and you're looking at UNA, the European Convention cases that I put in the bundle, you list. You have the factors, and the decision maker will, unencumbered by any statutory direction, give each factor appropriate weight.
He's done that, hasn't he, in paragraph 34?
Well, the crucial difference is, my submission is, that he specifically said, I don't accept that there should be any reduced weight, and that the full
He doesn't
force...
say that. What he says is that he doesn't accept that there's necessarily a reduced weight, following from the fact that the Acts deal with foreign criminals. That's what he actually disagrees with.
Well, I made a very specific and I think plain point, and it mirrored, I think, what I'd said in the first tier tribunal, that we're not applying the very compelling circumstances level. I mean, when you get to very compelling circumstances, and I'll come to the
But he didn't apply the very compelling circumstances, did he?
He applied the same exercise that you get when you get to section 117 C6, when you're looking at exceptional circumstances. You look at all the circumstances. You don't just say, is it unduly harsh or not unduly harsh? You look at, and it looks like an unvarnished exercise, but it's not. It's very much not. What it is you are giving preponderant weight to the public interest under 117 C6, because otherwise, why have all that legislation? And that's I've made the point, I think, very clearly. But those are my points.
Well, that's very helpful having your points. Now you want to take us to you said the facts.
The facts.
I think we have I think for my part, we have the facts fairly clear.
Right. And I don't want to in any way pretend that they are attractive, because I mean I think the position is that there hasn't been a deportation order. He still enjoys, therefore, his leave. But I'm certainly not saying to this court that should be treated in the way it would normally be treated.
Hang on. You say he enjoys leave. He's had his asylum status revoked, and he's had his indefinite leave to remain revoked.
Well,
so he's not.
I think actually the position actually is that he's yet to be subject to a deportation order, and therefore his leave is still outstanding, subject to this appeal. So he loses the appeal. The deportation order will be made.
There's asylum status, there's indefinite leave to remain, and there's deportation, removal from the United Kingdom.
Yes.
Deportation is where the state takes you away from the United Kingdom. Indefinite leave to remain means you don't have to leave voluntarily, but has he had his leave?
No, well, I think the point is that
yes, formally it is the deportation order that brings the indefinite leave.
Oh, right, so he's still got indefinite leave then, so he's not here unlawfully, he's here lawfully at the moment.
Yes, I will have more to say on that in a moment, but formally the indefinite leave to remain comes to an end when these proceedings are completed and the deportation order.
So his asylum status has been revoked, but not his indefinite leave.
Yes, that's right. But I'm not really making a huge point of that, because I understand the background to that, and the judge had it well in mind, and that was obtained by deception, and so I don't make any point about the fact that he's got that is a plus.
All right.
It's never been put in the plus side on this. What I say the unvarnished test should be. It shouldn't be there. That's that point.
Okay. So I think we're clear on the facts, but is there anything you specifically?
Well, could I just, in terms of the facts, if you're very clear on the facts,
do you want to?
I'm not going to labour them. They're set out in the upper tribunal determination. He takes the facts as they stood at the time of the first tier tribunal, and one can see that, that when he does find errors of law, I invited him to remit. He said no, and we haven't got permission on that. So the facts are, if you like, as they stand as of December 19. But my lord, if you are clear on the facts, I'm not going to take time in summarising what you're clear about.
So you were going to
Can I go
legal-
straight to the statute?
Yes, that.
Yes.
For my part, that would just
Yeah, absolutely.
quick reminder of that would help.
Yes, so we're looking at tab. So we're looking at tab. Well, the start. I mean, we should really look at tab 3, which is the general power to make a deportation order, and it's over the page on tab 4. We've got it's subsection 3.5. A person who's not a British citizen is liable for deportation to the United Kingdom if a secretary deems his deportation to be conducive to the public good. And you could also, it also then be another person who belongs to his family can also then be liable. But there are, so everybody who's not a British citizen comes under the category of people who could be deemed as liable to deportation.
If the Secretary of State is deemed as deportation to be conducive to the public good.
It's not
Yeah.
they aren't deemed liable to deportation, they are liable to
Yeah.
deportation.
They are liable.
Mrs. Gosturani is not liable to deportation because
Yeah.
the Secretary of State has not deemed it to be conducive to the public good. Mr. Gosturani is because the Secretary of State has deemed it to be conducive to the public good.
Mr. Gosturani, the Secretary of State has deemed him to be liable. Deemed his deportation to be conducive. He is somebody who's liable to deportation, and the Secretary has made that decision. Now, but that's a discretionary power. So the 2007 Act, in a particular category of cases, takes that discretion away from the Secretary of State. And that's at tab 2.
And just to complete, Section 5 says that when a person is liable to deportation, the Secretary of State may make a deportation order against him.
Yeah. And that discretionary structure is taken away at tab 2 because in respect of the foreign criminal group. Because at tab 32, a person who is convicted in the UK of an offence, and then condition 1, it's sentenced to imprisonment of at least 12 months, condition 2, 32. For those people, for the purposes of 3.5a, the deportation of a foreign criminal is conducive to the public good. So it's telling the Secretary of State that they are conducive, that their deportation is conducive, and then 5, the Secretary of State must make a deportation order in respect of a foreign criminal subject to 33. So it's mandating the Secretary of State. Over to 33, exception 1 is where removal would breach a person's convention rights. So it's 2A, and that's the traditional challenge. It can be also, there are other exceptions, 3, when person is under 18 at the time of the conviction. But the important point, and when I come to the case law, the Lord Justice Laws in SS Nigeria says, I'll come to it, but I'm going to stay with the statute for the moment. This is a huge step, and this is Parliament intervening and telling us what the public interest is. It's not a discretion, you must do.
It's telling us what the public interest is for a particular group of people. Those who've committed offences here, and they're serious, must go.
Yes, and that's my point, a particular group of people, which doesn't include the appellant.
Yeah.
So that's my point. It does make a difference. It is important. That's the first sort of statutory intervention, if I can put it. And this is how the case law, that's their word. I'm taking the words from the jurisprudence. This is an intervention. Clearly, it is. So part 5 is the next one, and that's tab 3. and this is even more prescriptive because I mean, part that the UK Borders Act, which we just looked at, takes us to the point of saying, well, you know, you've got to, it is conducive, and you've got to make a deportation order subject to human rights. But this is actually telling the court how to deal with those human rights. And so it's in 3 parts, and it 117A, which says that this part applies to all, in all cases. 117A1, it applies where a tribunal is required to determine a decision made under the Immigration Acts, whether it breaches private family life. And 2, in considering the public interest question, the court must in particular have regard to, in all cases, 117B, and in cases of concerning deported foreign criminals, the considerations in 117C.
But just pausing there, Mr. Lambs, does subsection 2 prevent a court or tribunal having regard to other matters in cases that concern people who are not foreign criminals as defined, but who have committed an offence abroad?
The way I know, what I say is this is a comprehensive, this is a complete. It's seen as the case law sees it, and the words suggest it's a complete code, and it caters for those who simply don't have leave to remain, and those who are liable for deportation because the Secretary has decided that has deemed them so as a matter of discretion, and that would cover the appellant in this case. It would cover other forms of criminality that fall below the...
But I think the question that my lady's asking really is, if you look at the words, what 172A means, that when you're looking at a general 117B case, you must in particular have regard to certain facts. Does that preclude you from having regard to other facts? You can't do it in the same way as would be done by the application of provisions which don't apply to them, but can you look at the substance of the factor?
Yes, I think you could look at all the facts, but you've got to look at it in a framework that's set out in 117B.
Sorry, what do the words in particular mean in 2?
Well, I mean, the section 117A and B, for instance, doesn't mention. Well, it's not wholly. I suppose it means that you can look at, for instance, family life in 117B that applies to non-foreign criminals, and you can look at all. You can apply like the Strasbourg tests. It allows that, and that's to look at a multi-factorial approach.
Does it mean that the factors to be taken into consideration when determining the public interest question are not closed, but the court must in particular have regard to the situations in 117B, and where it applies, 117C. Is that what it means?
Well, yes, but I mean, what it doesn't do is allow you to simply ignore, I would suggest, or to simply superimpose 117C on people, on those who are not covered by 117C, and just say, well, we're going to apply the same test.
Well, is it your case that the upper tribunal judge simply imposed 117C in this case?
Yes, he did. He did, because...
Well, where did he do that?
Well,
I probably haven't read the decision carefully enough, but where do you say?
what he does is he says that when he rejects my submission that the public interest is not the same.
No, this is where I think we disagree with you. And I understand what you say you submitted, but you need to look at what he records and what he is deciding. And he records, and he was dealing with a situation where you say that the legislation on the public interest in deporting foreign criminals excludes foreign nationals, it's paragraph 26, and therefore it follows that those convictions do not carry as much weight. And he disagreed with that because he didn't regard the two statutes as impliedly saying there's got to be a reduced public interest. And then he goes on to say you've got to look at the subject matter of the offence because you can't rely on sentencing. So that's what he's saying. He's saying you can't say automatically that it's reduced because it's a foreign criminal. You've got to look at the subject matter. Isn't that what he's saying?
Well, I would say what he's saying is he's saying that we should treat this conviction no differently than.
Where does he say that?
But where does he? You've said more than once that he applies the Section 117C test, and I'd just like you to show me where he does that, please.
Either in terms or in substance.
I think it follows from 26 and 27.
Well, what precisely in 26, 27? Where he don't, there's no reference to 117B that in 27, so it can't be in terms.
What?
Where is it in substance?
Well, the 2002 Act, he says.
What?
He said although the borders 2007 and the 2002 define the term foreign criminal, it doesn't follow that there's a reduced public interest.
That's not applying the 2007 Act. He's saying you can't assume that because the 2007 Act deals with foreign criminals, that when you're dealing with non-foreign criminals, there's automatically a reduced public interest. And what that follows from the last two sentences, the public interest is not reduced because the crime and conviction took place outside the UK. However, as explained above, the approach to assessing Article 8 is different, where the conviction is abroad, because the framework for assessing proportionality in the 2002 Act of the Rules does not apply. So he seems to be saying there, far from, but I'm going to apply the framework, he says, I'm not going to apply the framework, but I mustn't assume that there's automatically reduced public interest.
And then if you go on to the remade decision, paragraphs 33 and 34 to 36, he does a proportionality balance.
Yeah. But what I say about that.
So he doesn't say, I can only allow this appeal if there are very compelling circumstances outside the exceptions. There's no trace of that reasoning.
Well, Madam, what you have in the cases is the exercise that he conducts critically, and the exercise that any court will conduct when they're using 117C, when they're looking at exceptional circumstances, it looks just like that, because they look at all different matters, not just the conviction, but the critical point about the difference, I say, between what looks on its face like a sort of unvarnished.
But he says he's accepting your submission. It's got to be an unvarnished one. But you've still got to identify what is it that says it's in the public interest to deport Mr. Gosturani. He lied for 20 years about his immigration status, and he's committed a serious offence against women in Italy. And those indicate to the tribunal, absent other factors, this is not the sort of man who ought to be allowed to remain here. You then go on and look at the effect on his wife, and particularly the effect on his children, and also other factors.
Well, my lord, the test is the critical point is, are we placing the same weight in relation to the conviction as we would if it was if it was a conviction that was under 117C?
Well, do you accept that it's, I'm sorry to interrupt you, but do you accept that it is possible in certain circumstances that the same weight should be attached to a conviction outside the UK as to a conviction in the UK?
Well,
Is it possible?
it's possible at the end of the day.
Well, in those circumstances, how can you criticise the second sentence of paragraph 27 of his judgment? Because that's what he's saying. You asserted, without qualification in 26, that it doesn't follow that convictions do not carry as much weight. Sorry, it follows, those convictions do not, it follows, you said, that those convictions do not carry as much weight. Full stop. That's a unqualified assertion, and he didn't accept that. He said it doesn't follow. They may or may not. That's what he's saying in 27. He's disagreeing with your
Well,
you're unvarnished. You're unqualified.
my unvarnished is different from his unvarnished, and I think the reason why that is the case is that, I mean, he's also saying this well, when one looks at the case law, when you get to 117C 6, it is a multi-factorial approach, and it is a balancing exercise. And when you look at Hesham Ali, it is a balancing exercise, and you could be forgiven for saying, well, it's just a question of somebody going and applying appropriate weight, but it's not actually what that is, because in 117C you must apply weight that's commensurate with the very compelling circumstances test. So the criminality when you get to 117C 6, it is the subject of the statutory considerations. So it's very different from simply looking at all the facts and taking giving what appropriate weight you think to criminality.
Yes, but forgive me, so what? That's not the test which the upper tribunal applied. I just don't, at the moment, I'm just not understanding how section 117C6 is relevant to this case.
Well, if we look at the words of 177C6, it says, in the case of a foreign criminal who's been sentenced to a period of imprisonment of at least 4 years, not Mr. Gosturani, the public interest requires deportation unless there are very compelling circumstances over and above the fact that he's got children in the UK.
Yes.
But this tribunal didn't ask themselves, are there very compelling circumstances over and above the fact that Mr. Gosturani has a number of children in the UK who are British nationals and entitled to be here? He asked himself, on the one hand, he's lied about his immigration status and he's committed a serious offence in Italy. On the other hand, there are the interests of his children and his wife and the fact that he's run a business successfully. And it's a difficult decision, but at the end of the day, he thought it was justifiable. It wasn't a disproportionate interference with Article 8(1) rights to deport a person, notwithstanding the effect on others, but because of his own behaviour, his lying and his criminality.
Is what well, could I come to what I say is that in effect the standard that you apply at 117C6 is the standard that this judge applied.
I think you've got. I think for your appeal to succeed, you've probably got to show that, because I think you've accepted that a foreign conviction is a factor to be taken into account. You say in an unvarnished way. What you're saying is that he may not have expressly said, "I'm applying section 117C6," but that's in effect what he did, and therefore the whole process was infected. That's what you're
because he's giving the same weight to the conviction, the overseas conviction, as he would if it was the UK conviction. And that, I think, is the Secretary of State's argument that he should give, and he's empowered to give, and he should give the same.
Well, first of all, I think you've got to show that he did.
Well,
That he did give it the same way. I think you've got to show that. And
Well,
secondly, that if he did give it the same way, he did it in a way which was impermissible. Because it's possible, isn't it, as a matter of common sense, as a matter of as a logical proposition, that having conducted the exercise that you say he should have conducted and didn't, he would, at the end of the day, attach the same weight as he would have done had this been a foreign criminal to whom Section 117C
well,
C6 applied.
what he
The
did.
fact that he did apply the same weight doesn't
Well, I think
necessarily
that
mean he
goes to
should.
materiality.
Okay, all right.
That goes to my submissions on materiality, because if you accept that he didn't give the right weight, then then the question arises: then is that error material? And that was the submission that I would.
I think I probably lost you in my translation. I probably misled you in my. Simply because at the end of the day he ends up giving the same weight, having conducted the proper, what you would say would be a proper exercise. It doesn't follow from that the decision was flawed, does it?
Well, I would suggest that once if he's using the wrong weight, then one has to go back and then see, well, what relative weight do the other factors? So how do they then come into the balance? If you think of it as a sort of scales, I mean, if the weight
But
that
is that a matter? I mean, when we get to weight, isn't that a matter for him?
yes, but I would suggest that if he hasn't erred in the way I say he's erred.
Okay,
I know you don't. It's not a right way of dealing with these things. It's not the way that people deal with them. But say, for example, the Secretary of State has a point score and he says, "Gosh, serious offence, exploitation of women would have got 6 years in England. That scores 10." If the Secretary says, "Gosh, serious offence here, he's done terrible things to women in Italy, and he's got a lengthy sentence," I think that should get a 10 too. There's nothing wrong with that, is there?
Well, the 117C is about thresholds, and I haven't started to look at it.
No.
It's about thresholds, and if 117C doesn't apply, then 117B does apply to him, because it applies to everybody. So it also applies to him.
yes.
And there's no consideration of 117B in this in the
Okay.
exercise that we have.
Okay, well, I think what we better do is let you develop the argument.
Yes.
We focused on the points which are concerning us, but
Yeah.
it sounds as though you probably need a longer run-up to get to this point. So why don't you develop the argument in the way you want to?
Yes. I mean, in terms of 117, well, I was at tab 3.
Yeah.
117B. This applies in all cases.
Yes.
And maintenance of immigration controls is in the public interest, and then little weight should be given to private life where there is established when a person's here unlawfully. At 6, a person is not liable to deportation. Public interest does not require removal.
We're not in that. We're not in that.
We're not in that category, but I think, and then at C we've got the considerations that apply to those who are foreign criminals.
Well, that doesn't apply either.
Well, I mean, this is well, it doesn't apply, but it's instructive to look at the structure that must be followed in cases where it does apply, and by analogy we can say, well, that doesn't apply in the appellant's case, and it's instructive that this is the mandatory process, and you look at, and it's done in, it's not an open, it's not just a balance sheet.
No.
It's structured in terms of, whether you've got 12 months, or whether you've got under 4 years. And then a series of prescriptive tests are introduced that you can see the test of undue harshness that you are allowed to get to or rely on if you've got less than 4 years, and then if you're over 4 years, you get at 6 very compelling circumstances.
But this approach doesn't apply in the present case.
It doesn't, but what it does is it is an expression of Parliament's express view of how to deal with a certain category of conviction. And I say that, whether explicitly or implicitly, when this judge rejected my submission that there was a reduced, we don't use this test, we reduce it, that he made an error in reading across the same public interest, not a reduced one, when he conducted his proportionality exercise.
Okay. Can you show, you're going to come and show us in your own time, where in the judgment you say he did that?
Yes. Well, can I come to the submissions first in relation to just on part 5A. I mean, it is a comprehensive system, so it deals with those who are subject to immigration control but are not liable to be deported because the Secretary of State has not made any conducive decision about them. But it also deals, section 117B, with those who are liable to being deported, because there you've got the reference in 117B to 6, that those who are not liable to deportation don't get to benefit from 6. But it does show you that this framework is looking at 3 categories of people. It's looking at those who've got no criminal offences at all and just have got an irregular immigration status, and those who've got some level of criminality, say under 12 months, and I say the appellant comes in this category as well, because there is no mandatory process for him. So, and then you've got the third category as foreign criminals. But this scheme encompasses the appellant. You've got to fall somewhere within this scheme. You can't fall outside it.
But 177B can't be exhaustive and complete for a person who is liable to deportation and who is not a foreign criminal for this reason. That person may have 3 young children in this country, and that's got to be taken into account in his favour. And 117B doesn't say that you've got to take that into account. So there must at the very least be other things to be added, and the question is whether or not it is impliedly the case that you can't give the same view of seriousness, if you want to a serious offence committed abroad that you would give if that similar offence had been committed in this country.
Well, if I could put it this way, the 117B doesn't say you can't take into account the family life of those who are merely liable to deportation. What it says is that you don't have to make a concession in relation to them and say that they're because it says 117.6 is those who are not liable to deportation of public interest does not require the person's removal. So that is, if you like, a concession, but it doesn't mean that those who are not liable to deportation, so who are liable to deportation, which is, I think, the second category, aren't. It doesn't say that you can't rely on family life.
No.
It's like a baseline.
Well, go back to 117A,
Yeah.
which is what leads to 117B or C.
Yeah.
What we're looking at is, under 3, the public interest question being the question whether it's justified. Interference with the articulate right is justified.
Yeah.
And that's a question which can only be answered by looking at all the circumstances, isn't it? For and against. And the list in 117B is obviously not exhaustive. A, because it obviously isn't exhaustive looking at it, and B, because the words in particular in 117A2.
Yeah.
Let's take an extreme example. Supposing there was a man, this isn't your client, who'd been convicted of a string of serious offences over 30 years, in all of them abroad. Is that a factor which can be taken into account in determining the public interest question?
It can be taken into account, but you don't start from a prescriptive test and a prescriptive and preordained standard.
Yes.
And that is why, I mean, there is a presumption that it's only in very compelling circumstances, or whether there's a very high, a very good case to resist deportation. If those were
okay. Well, I think that leads us back to the same position. Sooner or later, you're going to have to show us why you say, in your own time, why you say the upper tribunal judge wrongly applied a prescriptive approach, as opposed to the more flexible balance sheet approach. Is that the right way to put it?
Yeah.
Unvarnished.
Unvarnished approach.
Okay, so we're going to get there in a minute. But what else do you want to say about the statute?
Well, that is the. So I say that it's important to consider that he does fit into the scheme, and he fits in at Part B and at Part A, but not at Part C, and therefore it's wrong.
I think we're with you on that.
Okay. The immigration rules are of similar effect, and I don't think that's in any dispute. But turning to the way in which this operates in practice, I think NA is probably a good place to look, and
So where are we?
This sets out, this is tab 23. This is setting out it's looking at Part C, and it's considering the very high standard that it imposes. At 218, page 218, at the paragraph 11, it deals with the sort of statutory background, and it deals with SS Nigeria there, and this is the 2007 Act, again, to which doesn't apply to the appellant, but I say this is all part of the framework. And paragraph 12, the Secretary of State, the Lord Justice Laws is saying that Parliament has attached Parliament in the 2007 Act attached very great weight to policy as a well-justified imperative for the protection of the public and to reflect public proper condemnation of serious wrongdoers. Sedley, LJ, was with respect right to say that in a case of a foreign criminal, the Act places in proportionality scales a markedly greater weight than other cases. So it's setting those foreign criminals apart from everybody else. If one comes to 117C and paragraph 22 at page 221 onwards, they consider the application of exceptions 1 and 2 within that part. They go over the page, 33. Although there's no exceptionality requirement, it inexorably follows from the statutory scheme that in cases in which circumstances sufficiently compelling to outweigh the high public interest in deportation will be rare.
Where are you reading from?
33.
33.
224. So the statutory scheme, where you have a foreign criminal as defined by 2007 Borders Act and Section 117C, no exceptionality requirement, but it inextricably follows from the statutory scheme that cases in which circumstances sufficiently compelling to outweigh high public interest in deportation will be rare. Now, that would not be the case for the appellant. The commonplace incidents of family life, such as ageing parents and poor health and natural
Well, you say it won't be the case for the appellant, but well, I suppose it depends on what you mean by that. The Act is silent about people in the appellant's case, except to the extent that they're dealt with in Section 117B.
Well, perhaps I can just concentrate on what I say is if you define the public interest as being particularly high for one category, you can't just read across to
You
another.
say the implication is the fact that Parliament has gone out of its way to identify one group and said this group is so bad, this is what happens to them.
Yes.
By implication, you say,
Yes.
Parliament must have thought it wasn't so bad for other things.
Yes. And you're not in, if you're not in C, then you're in B, and the baseline there is a different test altogether. We're talking about a balancing that is not supercharged, if you like, by these public interest statutory considerations.
No, but there could be, pick up on Melena's point, there could be circumstances in which the offences committed by someone abroad were on a scale that the circumstances would have to be high or compelling to outweigh the public interest.
Yeah. I mean, in this case, I say on the facts, he shouldn't have taken into account, and B, it did matter. We're not in that territory, and what I say is that this should go back to the upper tribunal for it to conduct the unvarnished exercise without that equivalence between foreign.
Well, we're going to come to the.
But could I?
It's our fault for distracting you.
No.
But keep on.
So 39.
Yes.
39 is that this is what is said about those to whom the statute applies. One would see it's so controversial because you are manipulating, if you like, the normal balancing exercise, that it requires reference to the margin of appreciation. And 39, it must be borne in mind that assessments under Article 8 may not be identical in every convention contracting state. To the degree allowed under the margin of appreciation, bearing in mind the convention is intended to fair balance individual rights and interests of the community. An individual state is entitled to assess public interest, which may be involved, different states may make different assessments of what weight should be attached to the public interest in the deportation of foreign offenders. So where Parliament has singled out this group, they can do it because they're Parliament. They can do it within the framework of the margin of appreciation. But you're pushing to the absolute limit because you're not just doing your balancing exercise. You're saying, well, it's got to meet a certain test, which is over and above what other states might require. This is why they're invoking the margin of appreciation. And we'll see, I'll come to Uanene, which is the European court case, where there is a real tension you can see between what the UK is doing and what the court considers acceptable. I mean, they didn't say the whole scheme is unlawful, but they, you can appreciate the real tension that the UK has pushed the public interest as far as it possibly can in respect of this group of people. And it's a, so that it's, I mean, that one way of putting it, you can see it 227 in 49. The starting point is a compelling presumption in favour of deportation of such foreign criminals. There's a starting point there. So that is there are I mean, the other point about this this part 5A is that it goes beyond what was there before, in the sense that before this statutory provision, you simply had regard to what the Secretary of State's policy was, but after it, the Part 5A forms a governing provisions as to how you apply the balancing exercise. It's a balancing exercise, but you're told how to do it with preordained thresholds. So that's NA.
Yes.
I said that it was draconian. Perhaps I could. Well, I say it is draconian. Perhaps not the right word, but it is extreme. And if one looks at tab 8, this is the European case, one can see that the tension here between the great weight that this imposes and what the European court would prefer, if you like. They discuss NA Pakistan paragraph 43, and this is at tab 8. 44, they quote the passage that I think I've already looked at, but although there's no exceptionality requirement, it inexorably follows that a very compelling test to outweigh high public interest in deportation will be rare. So you need, it's rare to find cases that succeed when you get into that territory. They contrast that with what Lord Kerr had said in his dissenting judgment at 48, I believe it was in MF Nigeria. It may have been Ali, in fact. But at 48, and they quote Lord Kerr, at 120, Lord Kerr says European cases do not permit national policy which limits or dictates the weight to be given to the multi-factors in an Article 8 balancing exercise. This is clear from, for example, the court's judgment in Untitled. All the multi-factors should be taken into account. And when it comes to applying Article 8, therefore, as opposed to purely domestic policy, it's not open to the Secretary of State to say that some multi-factors should be taken into account or should be subservient to others. That's precisely what, in fact, I would suggest that's how it actually works. If you've got that preordained weight, they must, over the page, they must be taken into account, they must be given weight they deserve, following an open-ended and rounded evaluation of the case.
Which paragraph are you on now?
This is page 767,
Okay.
paragraph 48, and it's an excerpt from paragraph 120 of Lord Kerr's decision. I think it's in Hesham Ali.
Yeah.
But this is when you ask the point was put to, well, what do I think is, it would be the correct approach. It would be this sort of unweighted exercise, and we just give appropriate weight to the criminality because it's not a foreign criminal case. That's what I mean really by unvarnished. There's no statutory overlay. And then what the court says, well, this doesn't, the scheme of Part 5A doesn't, it's not unlawful, but it's paragraph 80. This is what they say about it, 774, page 774, paragraph 80.
Well, I think you've got to start, one needs to bear in mind everything. Paragraph 70 says the state is entitled, as a matter of international law, to control the entry of aliens into its country and their residence there. Yeah. It doesn't guarantee the right of an alien to enter or reside, and the court countries have a power to expel, but there may be Article 8 issues, and amongst the things that are referred to in 72 are the nature and seriousness of the offence committed by the applicant, the reference to where it was committed, the length of the stay, and the time between the conduct and now, and that's various other factors.
That's all classic multi criteria. I've got, and that is exactly what I would suggest that should be done in an exercise of this case. But if you start from the proposition that you're not reducing the weight, the preordained weight that goes to the foreign criminal conviction, you're not reducing it, then the implication is that you're not using that sort of open-textured test, which I say should have been done. Paragraph 80, in the present case, the applicant argues that the tribunal was precluded by the immigration rules from conducting the assessment, and the tribunal's only discretion outside the rules would be to consider whether there existed exceptional circumstances or very compelling circumstances. As Lord Kerr observed, such a requirement would appear to run directly counter to the proper assessment of whether an interference with the right to respect private or family life on the part of those who do not come within one of the exemptions is justified. So that is why I say the European Court is...
Well, I'm not clear whether the European Court's there endorsing what Lord Kerr said, or whether it's just incorporating that in the appellant, the summary of what the appellant said. First sentence of paragraph 80. In any event,
I think
doesn't the European Court reach a conclusion at paragraph 82 and 83?
Well, it says 82 and 83. It doesn't, in all cases, mean that our system will be unlawful. It's not unlawful as such. But I would suggest that paragraph 80 shows that when it says "as Lord Kerr observed," there is. It says such a requirement would appear to run counter to the proper assessment. And my point is, I'm not asking you to make a judgment on whether the system is lawful or not. It just highlights that this is a situation where the margin of appreciation has been taken into account. We're at the limits of what would appear to be acceptable to the European Court, and it does depend on the margin. Paragraph 75 of the court of UNANE cites the margin of appreciation. That's before they get to the passage I've looked at. So they have well in mind that different states apply apply their own interpretations of the convention rights in their own way, and that goes back to paragraph 39 of NA. So that if we're looking at a point of wide principle here, there is a point of principle. They should we treat the non-foreign convictions in the same way.
Okay.
And I mean, the Secretary of State says we should in her guidance at
Well, all right.
tab 31. But I just say we're at the very limits of what can be lawfully done here.
Are you coming to the guidance?
Could I what I'm going to I will come to the guidance. But
Okay.
I just have a couple of further case references. And paragraph tab 17. This is CI Nigeria.
Yeah.
And it's at 20. And this is these are the examples of how it operates. The bottom, they're talking about the scheme of the rules, immigration rules.
Where are we tab 20?
Sorry,
17.
I'm at 17. I'm at
CI Nigeria.
I'm sorry. I'm at tab 17. I'm at paragraph 20, and it's at the bottom. It is one of a number of cases where the line is that this is effectively you don't even need to look at anything other than Part 5A. There's no room for further assessment of proportionality under 8.2 because the statutory provisions determine the way the assessment is to be carried out in UK law. And that's the bottom of paragraph 20.
I'm so sorry, it's my fault, Mr. Lambs. Which authority are we looking at?
I'm looking at CI Nigeria.
CI Nigeria, thank you.
This exercise is said to produce in all cases it's a structured Part A taken. The provisions of Part A taken together are intended to provide a structured approach to the application of Article 8, which produces in all cases a final result compatible with Article 8, and then the further authority is quoted there. And in such case, there's no room for any further assessment.
Yeah, but forgive me, Mr. Lambs, you've missed out a sentence. In such cases refers to if applying section 117C3 or 6, doesn't it?
Well, Part 5A is
In such a case.
is B as well.
Yeah, but
Part 5A is
well,
A and B and C.
I don't read Lord Justice Leggett as I read that sentence in such a case as applying to a case under section 117C or 6.
Yeah.
Because of the way
I mean,
you say that applies to B as well.
Well, Part 5A, that's the wording. It starts provisions of Part 5A taken together.
No, the paragraph starts with paragraph 398, 399A. This is all about foreign criminals, isn't it?
Yeah.
And that's why it doesn't really help to take sentences out of context. What was the case about? It was all about somebody living here who committed an offence here, wasn't it? And therefore, not surprisingly,
That's right. But,
Dr. Elisabeth was dealing in paragraph 20 with those bits of 5A that apply to this. He wasn't writing a treatise about immigration generally.
All right. Well, the wording of Part 5A is in the middle of the paragraph. He does include the whole, but I mean, my point is.
Well, now, let's just nail this down. As my law points out, paragraph 20 is about foreign criminals.
Yes. Yes.
Okay. So in those circumstances, how does 117B come into the picture?
Well, I'm just saying that there's a general statement midway through.
Yes, but it has to be read against the background
Yeah.
that the court was thinking about a foreign criminal.
Yeah.
It didn't have in its mind, what about people who
It
commit crimes abroad?
may be that, but what I say is that again, this tells us that about the great weight that is applied to a particular group of criminals, which doesn't include the appellant, and by implication, we don't use the same prescriptive tests or attribute the same public interest weight to those types of convictions, because they are singling out here convictions that are 116. I agree, but that is my point, that in this and other cases, any Nigeria, which is tab 22, again, it's the same point that that you're looking at a structured approach when you're looking at a domestic conviction that has a prescribed test at the end of the day. Paragraph 14 of it's a similar point to CI Nigeria, but so it's paragraph 22, and it's
Sorry, tab 22.
sorry, tab 22, paragraph 14.
So NEA. Yep.
NEA, and again, it's making the point that
14.
it's at the bottom. 14. It's at the bottom of 14. Starts at the bottom of the page and goes across. At the top of page 7 of this authority, we can see that there's a contrast here between the rules and Part 5A. And in Part 5A it says the rules don't govern decision making, but this does govern. Part 5A does govern decision making. It's primary legislation directed to tribunals governing their decision making in relation to Article 8 claims. Taken together, it's a structured approach to Article 8, which produces in all cases a final result which is compatible with Article 8.
In particular.
In working through the structured approach, one gets to 117C, the proper application is that of that provision produces a final result compatible with Article 8 in all cases to which it applies. So this is again emphasising, and at 15, again, there is no, at the bottom of 15, paragraph 15, the last sentence, there's no room for any additional element of proportionality in the balancing exercise under Article 8. Because you're confronted with a test of very compelling circumstances, and either when everything is balanced, you meet that test, and in doing that, you put very great emphasis on the offending in the UK.
I mean, for my part, I read paragraph 15 of this authority as being focused on 117C6.
Yes.
Because it's all about foreign deportation.
Yes.
As in the previous case,
Yes.
it's all about the deportation of foreign criminals
Yes. Yes. And what I
sentenced to at least 4 years imprisonment.
why I look at this is because I say this is what the substance of the test that the judge was using was this test. It wasn't, and that's commensurate with it's the way in which the judge had approached it, it's the way in which the Home Office approaches it.
I think you are aligning two things. There is, in abstract terms, the view you take of criminal conduct, is it bad or not bad, and the process by which, the labels by which you decide what to do about it. The second part, the labels you attach and the test, is 1176C, whatever it is. It's got to be very compelling circumstances, and that may be able to account for everything. But we are at an earlier stage. Take a situation, if somebody attacked a man with a knife in King's Cross before he got on the Eurostar and he got 4 years, we know what the position is. You go to 1176, whatever, and it has to be very compelling circumstances. If he attacks a person in Calais, going the other direction, with the knife, does exactly the same things, the question is it open to the tribunal, firstly, to say, well, that's just as serious. We don't want to have in our country people who do that kind of thing. Had it been at the King's Cross end of the tunnel, they'd have had to structure their decision by saying, well, does he have this, does he have that, are there very compelling circumstances, and so on. You don't do that in the case of the man who did the attack in Calais, but there's nothing to stop you, is there, in the act to say, well, stabbing somebody in Calais is actually just as bad as stabbing somebody in Dover. Yeah. And I'm going to treat that very seriously. And if you want to put it into language, there's a very high public interest in not allowing people who are foreigners to be in this country if they're going around stabbing people, wherever they're stabbing them.
But it's not preordained that you start from a test of very compelling circumstances. In the Calais.
You can see that I'm saying two things. If the judge has said, unless there are very compelling circumstances, this person has to be deported, even though it's a foreign case, that would be wrong. But if he doesn't do that and says, gosh, the kind of conduct here, irrespective of where it was committed, is so serious that it's not in the public interest for that person to stay in this country unless there are other countervailing factors.
Well, I suppose that comes back to the interpretation of what the judge said.
Yeah.
Well, we're going to come in a moment to looking exactly why you say the judge approached it in the way I understand the way I think what your case is. But we'll have to, when we get to the judgment, we'll have to see if that's how the judge approached it. So we've now looked at HNA. Have we finished with HNA?
Yes.
So NEA. Nigerian.
Binaku is at tab 27.
Okay.
And this is a case of somebody who had re-entered in breach of a deportation order. There was a rule, an immigration rule, saying arguably a different test applies in those circumstances. The tribunal say, no, that's not relevant. The only thing that's relevant is, again, this complete code under Part 5A. And so if there are rules that are inconsistent, immigration rules that are inconsistent with Part 5A, they're simply to be disregarded. And it just emphasises, again, at paragraph 74, there's a submission, again, that structured approach produces in all cases a final result compatible with Part 5A, and that's sort of taken up and accepted, and 91 follows from the structured approach that in the context of deportation, begins and ends with Part 5A of the 2002 Act. That's paragraph 91 of page 19.
Once again, we're concerned with the cases plainly within 117C's.
Yes.
Yes. And that's
So
it's clear from the head note in the line.
It's the same point, effectively.
Okay. All right.
In a different way.
Thank you. So, is that the authorities?
Well, the SC or Cookage is an authority that the Secretary of State relies upon, and which the appellant, the judge also, looked at. So it is important. It's tab 28.
Yeah.
Because there was an issue as to whether or not the immigration rules, the interpretation of the tribunal before this case was that the immigration rules did cover the appellant because he was a person who was both criminal and foreign.
Yes.
And so they thought, well, that must be relevant. But that's the upper tribunal says no, that's not relevant. That's not the right interpretation. It only applies to those who are defined in the Act.
Okay. So where did we go to?
That's 71.
Justice Lane's report.
That's paragraph 71.
Right.
That you must read the rules with the you must construe because foreign criminal isn't defined in the immigration rules, but you must construe the term foreign criminal in the immigration rules.
Okay, so 71 knocks that point out.
It adopts that point.
Yes.
And then at 72, you've got the position here. This is the Secretary of State's policy that I've been talking about. Where deportation is solely on the basis of overseas convictions, the person liable for deportation will not meet the definition of foreign criminal and will not fall within the criminality thresholds of 398. But the rules must be used as a guide because they reflect the balance to be struck between individual private life and family life and the public interest.
Yeah.
So they're saying you should actually use the same standard for overseas and for foreign criminals.
Well, does it say that?
Well, it says it should be used as a guide.
Yes.
And so...
doesn't say the same standard.
Well, I mean, they did in fact. I mean, we look at the refusal letter in this case. They did apply the rules, and they did apply the very compelling circumstances.
We're beyond that because the upper tribunal did it itself.
That's right, but my learned friend's case is that this is right, 72 is right, and that you should be using the same standard.
No,
well, I mean, maybe
used as a guide. I'm not going to. I don't agree that the same standard is the same word as used as a guide.
Well, I'm
just so it can be addressed, the assistance I derive from the immigration rules on this aspect is what follows in the paragraph, in the next paragraph.
Thank you.
Yeah. So at 73, they're looking at SEC 1.4, and there is a structure here of 4 years and 12 months that bears some resemblance, I suppose, to the 117C, but it's subject to the human rights, as you see at the top of the next of page 13. And at 74, SEC 1.4, again, it's a reference to human rights as being an exception to that. And so I say, when you look at those provisions, you're back effectively to a scheme which draws a distinction between the two convictions. I say that.
Well, this is about.
Well,
This is about the an appellant who is in the category of this appellant.
in this case, the appellant had committed a serious offence abroad. Yes, murder abroad.
And was seeking. What was the nature of the application?
Well, he was resisting. Obviously, it was. Well, it was. I think it had started out by an application of the immigration rules that they had included that as they read the immigration rules to mean that the deportation. They'd read the immigration rules to include that foreign conviction in the same category, because that was the reading of the immigration rules that they then said it was wrong. Because previously the reading of the immigration rules is that it includes a foreign conviction.
Okay.
They said no, it doesn't include.
Well,
so that's how we got to that stage.
At the moment, I'm not clear quite how Mr. Tomlin's going to put it. Why don't we let's hear how he puts it, and we'll come back to. You can reply on that if we need to. So, what else do you draw from this authority?
Well, the basic point is the point at paragraph 71 about the proper construction.
I don't think you're going to.
The second point is that it's in reply, if you like, to what my learned friend has said, that although, and my friend will. My learned friend will correct me if I'm mischaracterising here, but even though Part 5A and specifically Section 117C doesn't include foreign criminals, the public interest is similar or the same, and you can derive that by looking at these rules. That's broadly what I understand the argument to be. And that's actually accepting the central premise that, you know, what was an issue is whether the judge was right to attribute that same weight. But I know that. But
so did you say that aspect of if that's what
the judge did,
if that's what SC decided, it's wrong.
Yes, I say that is wrong, because you're effectively applying this highly controversial extreme test through a side wind, which is you know, rules on entry clearance and rules on admission to the UK that are not deportation rules,
Right.
and they don't. And when you look at those rules, you're led back to the question:
okay,
is there a breach of fundamental human rights? And once you get to that, then you're back into, well, how are those? You're back into Part 5A.
okay.
So
well, no doubt Mr. Topman's going to develop that.
Yeah.
I say no doubt.
So,
If he does, then
sorry, I haven't read this case yet. Is this a deportation case or something else?
Yes, it's a deportation case, but it's very similar to this case in the sense that it was based on an overseas conviction, murder in this case. Yeah. And that's the context of it. I mean, what the tribunal, I think, are saying is, well, we'll look at these other provisions and we derive that there is the same public interest, notwithstanding that it's not there in black and white, and then we apply it, and we're applying it, you know, giving it this full weight, and they 114. I mean, the terminology I think varies a bit, but 114 it wouldn't be unduly harsh on the children. and that's a term that you undue harshness is a term that's straight out of
Yes.
117C 6. Sorry, 117C 117C, not 6, but and it's there actually in 6 as well, because when you get to 6, you're also, and this is NA Pakistan, you're also considering whether the exceptions, whether there was undue harshness for the children, but you need something over and above undue harshness for the children.
So you say SC was wrongly decided, do you, for that reason, because the judge approached the upper tribunal approached it through the prism, effectively, of 117C, which it applied across when it shouldn't have done. And you say, and you're going to show us why you say the upper tribunal in the present case did the same thing.
Yes, and in fact, the upper tribunal relied heavily on just this particular case. And in fact, bases the reasoning about why rejecting my submission about the similar weight on this case.
All right. Have we finished the authorities? I know I'm pushing you.
Yes.
So good. Well, thank you. That's helpful. And then we're now going. Where do we go next? We're going to go to the decision.
Go to the decision. Yes. Well, one other authority is MW, and
Sorry?
One other authority. Let's go to the decision first.
Okay.
One has it at tab A at 47 and 48.
That's where we should go, is it?
So there's my submission at the 26th that the public interest is not the same between foreign criminals and where there's a non-UK conviction. I disagree, and I think that's important. And at 28.
Well, let's just, forgive me, let's just go through what he said at 27, if this is helpful.
Yes, well, he says this
He
is
said, although the second sentence we've already looked at, and you disagree with that, you told us, he refers to SC, he concludes there is therefore plainly public interest in excluding foreign nationals convicted of serious crimes wherever that crime took place. The public interest is not reduced because the crime and conviction took place outside the UK. However, as explained above, the approach to assessing Article 8 is different where the conviction is abroad because the framework for assessing proportionality in 2000 tax and the rules does not apply in the case of foreign nationals convicted outside the UK. Well, let's just dissect that. You agree with the last part of that last sentence. You say the framework for assessing proportionality doesn't apply.
That's right. What I mean by that is that you don't
have to show very compelling circumstances to deport somebody, to resist deportation if you're somebody who committed an offence abroad.
No, I say that the way in which you don't go through the structure.
You don't do the structure. You don't do 117C structure doesn't apply.
It doesn't apply.
Okay.
But the question is whether the public interest, because whether the public interest is the same or not at that very, very high level. Because if it's the same, it's not going to be the same as the unvarnished Article 8 assessment, because in the unvarnished Article 8 assessment, you're not weighting a UK conviction or any conviction in the same way and giving it preponderant weight and requiring a very, very strong Article 8 claim to defeat the countervailing considerations. And that goes back to that tension that we saw in the European case, Untitled. And the scales, I think it's, what I would say there is a similarity, because in both exercises, one that's driven by the one that was conducted here and the one that I say should be conducted are on the face of it, they look similar because it's what's called a multi-factorial approach. So you're looking at all the different factors. But the thing about if you're giving the same weight, if you're treating him effectively as a foreign criminal, then one of those factors is being given preponderant weight, and that's the criminality. And that's what the whole structure of 117C, well, that's the point of 117C6.
Okay.
And
well,
you're not,
let's what part of 27 do you disagree with? I think you've told us, you did tell us you disagree with the second sentence. The third sentence is just a summary of SC. Don't worry about that.
well, it says the issue was recently considered SC, where it was noted immigration was concerned. I disagree with 1.4. He quotes EC 1.4, and he says that's the route. Therefore, for a public interest in excluding foreign nationals convicted of serious crime wherever it took place.
Do you challenge that statement? There is a public interest in excluding foreign nationals convicted of serious crimes?
But the next sentence is...
Well, just a moment. Do you disagree with that sentence? There is, therefore, a public interest in excluding foreign nationals convicted of serious crimes wherever that crime took place.
That's compatible with an unvarnished...
Yes.
But it's the next sentence. The public interest is not reduced because the crime took place outside the UK. He says it in terms. He says it in terms there. And I think the whole point...
It all depends on what you mean by that sentence. I've been reading it as, it doesn't become less serious, less important, less dreadful, because he exploited women in Italy rather than women in England. I don't necessarily read that as saying, I've got to treat this as so serious that he's got to be deported unless his other Article 8 considerations are really, really, really compelling.
And if there's any doubt about that, the next sentence makes that clear, doesn't it?
Yeah.
Because he says the structure doesn't apply, framework doesn't apply.
Well, it's not so much the structure is,
framework.
The framework is, do I cite that particular bit of legislation? Do I then ask, is it 12 months? Do I then ask, is it 4 years? Do I then ask, is exception 1 apply? And then do I ask if exception 2 applies? That's the framework, but it's the substance. And I think it's important that he says it's not reduced. So
isn't he just saying the mere fact that a serious offence has been committed outside the UK is not a reason for treating it less seriously than an offence that's been committed in the UK? So he's just saying the mere fact that it's outside the UK doesn't mean it's less serious. And whether or not it is as serious depends on a number of things, including the sentencing regime. See paragraph 28.
Well, I would read it as saying there is a public interest standard. All the cases have said that come from the starting point that you've got this almost immutable standard of very compelling circumstances. That's not only giving that's not only descriptive, but that's descriptive of the test at the end after you've considered and balanced, and it's also about placing weight on criminality. So it comes in both, where do I weight the conviction, but also it imposes a test at the end, are there very compelling circumstances? Part 5A is about what the public interest is. And if you set the bar that high...
Yes, but he's not doing that. Public interest covers a number of things. Is it a bad thing to commit crimes here or abroad? Answer, yes. Then you work through 176 or whatever, and you say, is it necessarily so bad that notwithstanding children and everything else, he's got to be sent back? And the answer is yes, if it's over 4 years and there aren't compelling circumstances. The judge recognises you can't do that, but he's saying no more, is he, than it's not a good idea to commit crimes against women wherever you do it, and if you commit crimes against women, ignore the word public interest, that is something, the fact you committed crimes against women, which will count against you in deciding whether deportation is a disproportionate interference with your Article 81 rights. If you forgot the words public interest and ask yourself simply, is this a bad thing which should count against him? Is it a less bad thing because the victims are in Italy, not England? Then it's all right, isn't it?
Well, I would suggest this is not just about, this is about what category you're in. And if you're in the category of foreign criminal, then you're starting from a position that you're in a category that Parliament has singled out, and you can't. It's not just about the offence. If it's equally bad or not equally bad. It's what category am I in, and Parliament.
What do you mean by what category?
Well, I am in the category that Parliament has defined as singled out, both in the UK Borders Act and in Section 117C, which is those who have committed so-and-so offences in the UK. And it's the Parliament has drawn that distinction.
Yeah.
And that
certainly tells us what happens to people who do things in England. Parliament doesn't like that at all, and they're out saving exceptional circumstances. But the question is, can you infer from that Parliament has taken a view as to how a tribunal should respond to somebody who committed the offence abroad? And has Parliament said, and don't worry about that quite so much, that isn't quite so serious, the public interest is reduced. After all, he only stabbed a man in Italy. If he'd stabbed him in England, it would have been very serious indeed. Can we infer that that's what Parliament intended?
I think we do infer that, in effect, because Parliament has said this group of people, we're singling them out for mandatory deportation. Where you commit offence does matter in the sense that, is the public interest a sort of worldwide thing? Does it cover every offence in the whole world forever?
Well, but you don't want to have serious criminals in your country, is one thing, but it's not as simple as that, because you've got Article 8, and you've got to weigh it against everything else.
It's how you weigh it, my lord.
Yeah, and that's the question, is whether he did it in an unvarnished way, in the sense that he said, well, this is very serious, he did this in Italy, but it doesn't matter. It's also very serious because he lied for 20 years, but look at the effect on his children.
Well, if the public interest, as defined by Parliament, didn't really make a difference, then we wouldn't need to have 117C at all.
But it does make a difference, because you've got to go through a very precise set of hoops if you did the offence in England. And there are very limited exceptions to when you will not be able to treat that as outweighing it. But when you get to non-UK convictions, it's different. It can be serious. Exploiting women in Italy can be a very bad thing, and this was a very bad thing. And the question then is, right, I don't like that. What's against that? And the answer is, well, he's got these children in England, and they would suffer. But that isn't something that's prohibited, is it?
No, I say that's all perfectly permissible, that you can, if this is remitted to the lower tribunal, the upper tribunal, to look at all factors and to weigh them, but not with the gloss, if you like, or the preordained public interest, which is, as I say, it's been supercharged effectively by Parliament.
If you look at paragraphs 33 and 34 of the decision, that was why he took his view about whether or not round 2 to show that the tribunal had made not just one error but 2 errors. And he said, no, it's only made 1 error. But if you look at 32, and in particular 33 and 34, that's when he started to apply it. And in 34, he says, I'm going to do an unvarnished one. I'm not going to use the proportionality. And at 34, doesn't he list the factors without any preconception? And what he says is, lying for 20 years is serious and flagrant. Secondly, it was a very serious crime in Italy. There is a public interest in not allowing foreign nationals who are serious criminals. The severity is such that even though it happened a long time ago and there's been no further repetition, it's a factor that weighs heavily against him. Isn't that exactly what you say he should be doing?
And it's what he said he was doing, because he said he accepted your submission about the unvarnished approach.
Yes, but my submission about the unvarnished approach, part and parcel of that submission was that you can't use the same public interest standards.
But
That's what he specifically rejected.
If you use the word counts against him, it's the same thing. That's all the public interest means. It counts against him.
I would suggest that you have to read what's said in
33 and 34 against the light of 26 and 27.
Yes, that's
Is your
right.
submission.
And what were the issues in the case, and how was it argued? And if you say, well, you're not reducing the public interest, and you're saying that I look at I'm looking at SC, and I'm reading into those provisions of 1.4. I'm reading into them, in effect, the same standard. I'm not reducing the standard. That's the middle of 27. Then it follows that you're using the very high standard, and
Okay.
that's my case.
I think it may be that your best point was, and be careful when you accept what a judge says about your best point, because perhaps your best point, or a point in your favour, is the citation from SC that appears in the middle of 34.
Yeah.
Because it may. Do you say that at that point, despite the fact that he was warning himself that he wasn't applying the 117C framework,
In fact,
he was there adopting what had been said in SC, which on your case is wrong.
Yes, I think that is it. He's going back to those arguments that are made in SC, which I say are wrong, and they're based on the equivalence of reading across the same public interest, not a flexible concept.
And you're saying that although I took issue with your phrase that in SC the tribunal was applying the same standard, I said no, because to guide, that being the word used, I suppose you would underline, as I just have, the last sentence of the citation from SC, which is, this means that the appellant must show unjustifiably harsh consequences.
Yes.
So that's really your. Is that what your case is? Comes to the heart of it.
It is.
There, despite the warning, you're saying that he was. That's what was just Laing tribunal were doing in.
And if there's any,
that's what's happened.
and if there's any doubt about it, I would suggest that, given that he then goes on to say that this is a finely balanced case, well, those are my words, finely balanced, but he says that 37, he says, in a case in which the factors weighing heavily on both sides of the proportionality scale, this is a case where it weighs heavily on both sides. And then I'm satisfied that the very substantial public interest in deportation outweighs the factors weighing in his favour. Now, I'm not saying that you couldn't come to that conclusion if you'd done an unvarnished exercise, but I mean, when you look at the decision as a whole, he's maintaining, there is a danger, certainly, that in his mind it was maintained, that there was an equivalence between...
So he could come to substantial weight, but not in the way that he's done, because he's treating himself as bound to say substantial weight.
Well, that last sentence, I mean, you could read it in different ways, but I think it's not inconsistent with my reading of what's actually gone on here. And I mean, I had understood that the submission is from the Secretary of State, and again, maybe I'm putting words into my own friend's mouth, but that it is the same, and he would be fully entitled to read across the very same public interest. My lords, as I understand it, you're saying, well, in fact, he didn't. But I mean, the point of why public importance here, of course, is is that right or not? And I would suggest it's certainly not right, because Parliament has spoken on this issue, and that the corollary of treating that foreign criminal group in one way is that you're not treating the others in the same way. In terms of my submissions on, I have submissions in relation to family life, etc.
But you've not got permission there, and it's enough for your purposes to say, if he's got the weight wrong, we don't know how the balance would have gone. You can't get grounds 2 and 3 in by subterfuge.
No, the only point the only point I will say is that Mullenford does say in his skeleton, well, even if everything is, even if the judge applied the wrong test, it's not material, and I think I'm entitled to therefore say that it is material, and it's only in that context that I mention these points in relation to what is said about...
36 ABC, isn't it?
Yes, can I make a suggestion on that? If there is anything my learned friend wants to respond to,
Yes.
of course, in my submissions...
Okay. Let's deal with it that way. Let's see how far Mr. Tomlin gets on that. Right. Anything else you want to say there?
No.
Right. Elizabeth, do you want to go straight into him now?
You can have a chat.
Yes. I think we'll just rise for a few moments just to see if Blake stops.
All rise.
Retrieve one of these. Oh, of course. Sorry. I will return it.
All rise.
Yes, Mr. Turner.
I will take my submissions in two parts. First, I will consider the legal framework as it applies to foreign nationals committed offences abroad. And secondly, I will look at the submissions made in support of the appeal. The headline submission that I have is that the judge conducted his Article 8 unvarnished proportionality balancing exercise in an exemplary way. But I recognize one of the reasons we are here before you is because this is an interesting point on which neither the 2002 Act nor the immigration rules speak directly. And hence, it may assist at the outset to say what I submit is the appropriate reasoning process to adopt in that context. I have the following 6 points to make. The first is that the starting point in the context of a deportation order made under Section 35A of the 1971 Act, on the grounds that the Secretary of State deems deportation conducive to the public good in respect of an offence committed abroad, is not supported with the type of substructure that we now have in the 2002 Act for offences committed in country.
So can you just say that again? I think I missed a bit of it.
Yes, it's not supported by the type of reasoning process substructure that is now found in the Nationality, Immigration and Asylum Act of 2002.
Yes.
Nor is there express provision dealing with that cohort of offenders within the immigration rules. I say secondly that it follows that as a matter of first principle, the inquiry in this context is whether deportation is proportionate in the case before the tribunal, balancing the strength of the public interest in the deportation of the offender against the impact on the private and family life aspects that are brought to bear. And I say thirdly, that a helpful starting point for that exercise are the factors already identified in the Strasbourg jurisprudence as bearing upon the proportionality balancing exercise under Article 8. And fourthly, that in conducting that balancing exercise, it is appropriate for the tribunal to give appropriate weight to the views both of Parliament and of the Secretary of State formulating policies as the accountable Minister for Immigration Control and the public protection interests arising under that. I say, however, that fifth, the bottom line is that the critical question remains at all times whether the private and family life aspects relied upon are sufficiently strong to outweigh the public interest in the deportation of the criminal. And sixth, that one helpful, commended way of structuring the inquiry outside the section 117C framework is the balancing approach, commended by the Supreme Court in Hesham Ali, or rather, Supreme Court Justice Thomas in that case.
Okay.
And that within that balancing approach, one brings to bear the factors identified in Bultif and others, but also, of course, because it is an unvarnished balancing exercise, aspects such as the question as to whether family, private life was commenced in circumstances where those relying upon it were fully aware of the precarious nature of that.
You must have particular regard to the 117B factors. You've got to take those into account.
Absolutely.
You're not allowed to ignore those in any circumstances.
No.
Okay. Thank you.
And in terms of how Part 5A assists in that process, I entirely accept that one needs to travel through Part 5A as part of this inquiry. The relevant provisions which the tribunal must take into account are those in section 117B.
Yeah.
But I say 117B, A and B do not say in terms and cannot sensibly be read as a complete code which deals with all aspects which may arise in the context of the deportation of an individual who's committed offences abroad. Assistance for that, if required, I think the court has this. First of all, the wording in particular.
Yes.
117A, and then 117B, part 6, where it says in the case of a person who is not liable to deportation. Again, that rather begs the question of the factors which are relevant in the case of a person who is liable to deportation, and there we fall back on the Strasbourg jurisprudence.
Mm-hmm.
So that is the framework. In terms of the authorities that I rely upon to make good those submissions, I can be very brief. Ali, Hesham Ali, it's a tab 24, paragraph 50. I'm minded to take you to it simply because the Supreme Court there summarizes the first three stages of my analysis at paragraph 50. In other words, the Supreme Court says, in summary, therefore, the tribunal carries out its task on the basis of the factors it finds them in the evidence before it, the law as established by structural case law. Ultimately, it has to decide whether deportation is proportionate in the particular case before it, balancing the strength of the public interest in the deportation of the offender against the impact on private and family life. In doing so, it should give appropriate weight to Parliament and the Secretary of State's assessments of the strength of the public interest in the deportation of a foreign offender, as explained in paragraphs above, and also consider all factors relevant to the specific case in question. The critical issue for the tribunal will generally be whether, giving due weight to the strength of the public interest in the deportation of the offender in the case before it, the appellate claim is sufficiently strong to outweigh it. In general, only a claim which is very strong indeed, compelling if put in MF Nigeria, will succeed. Now, I need to flag up that the very final sentence needs to be read in the context of the case considered by the Supreme Court in Ali, which was one which did fall within the foreign national offender provisions within the immigration rules.
Yeah.
I don't place reliance on that aspect, but I do place reliance and endorse what is said by Supreme Court Justice Thomas at paragraph 82.
So this was a 117C case.
This was considered under the immigration rules.
I think section 117B had been enacted, but it wasn't in force at the time of the
Thank you.
fact, so it was the immigration rules.
Under immigration.
And
It's not 117.
No.
Thank you.
Not.
And the second aspect that I derive from this case is paragraph 83 of Thomas's opinion, where he says, one way of structuring such a judgment would be to follow what's become known as the balance sheet approach. After the judge has found the facts, the judge should set out each of the pros and cons in what's been described as a balance test, and then set out reasoned conclusions whether the countervailing factors outweigh the importance attached to the public interest in the deportation of foreign offenders. On my next submission, the Strasbourg authorities, we've already been taken to the salient principles. The most helpful place I found for them to be summarized was at tab 8 of the authorities bundle in the case of Unuane. Hoping my lords will have marked paragraph 72 still from a moment ago. Yeah. And you'll see there the factors. One of the factors there is bullet point 1, paragraph 72, the nature of seriousness of the offence committed by the applicant. You'll see that there are a number of other factors, the length of the applicant's stay, the time elapsed since the offence is committed. Paragraph 73 adds helpfully the best interests and well-being of the children. And also another bullet point, the solidity of the cultural, social and family ties with the host country, the country of destination. Paragraph 74 says all the above factors should be taken into account in all cases concerning settled migrants who are to be expelled and included following criminal convictions. And then 75, mirroring what we looked at a moment ago in the case of Hesham Ali, in assessing whether an interference with the right protected under Article 8 was necessary in a democratic society and proportionate, whichever aim pursued, the contracting states enjoy a certain margin of appreciation. However, as the state's margin of appreciation goes hand in hand with European supervision, the court is empowered to give a final ruling as to whether expulsion is reconcilable with Article 8. The court then, as you would have seen, endorsed construction of the immigration rules in Hesham Ali,
yes,
82 and 83, but as you will also recall, on the facts, the court found that the Secretary of State had not struck the balance in the appropriate way because the Secretary of State had not conducted the requisite separate and careful analysis of the position of one of the applicants.
Was it the Secretary of State or the upper tribunal?
It may have been the upper tribunal.
I think they were criticising the decision of the tribunal, weren't they?
Yes, they were. I'm grateful.
Right, yes.
I've already taken you to Hesham Ali on the weight to be given to the views of Parliament and the accountable minister. How that becomes, how that may play into a case such as this is illustrated by the case of MW, which you haven't looked at yet. The decision of this case found in tab 25. Now that is a case concerned with application for entry clearance. The American applicant had committed offences 4 years and a second one of 16 months. The relevant provision is SEC 1.1, SEC 1.4. We have that in the bundle, but you'll find it conveniently also paragraph 9 of the judgment. Paragraph 35 this court sets out the reasons why it is appropriate to give some weight to SEC 1.4. Provisions were laid before Parliament, subject to negative resolution, once the question no longer arises as to whether they operate as a constraint on judicial.
Where are you reading from?
Looking at paragraph 35.
Thank you.
Decision.
Sorry, thank you.
once the question no longer arises as to whether they operate as a constraint on judicial consideration of convention rights, it seems to us unnecessary to examine further whether paragraph SEC 1.4 bears quite the authority of other provisions placed in the statute. Provisions do represent an authoritative statement of public policy, broadly consistent with the 2007 Act and the new rules, and as such must be considered carefully and expressly by a court tribunal, considering the cases to which they apply. That extent of endorsement was, however, coupled with a number of points of caution, and those you'll find at paragraphs 39 to 41. I've set out the salient parts in my skeleton argument. Broadly, the advice is a degree of care needs to be applied in deriving from the foreign length of sentence, particular public interest in deportation. And similarly, a degree of care is required in examining the circumstances and nature of the offence the individual is charged with.
So you say that again, I just didn't hear you.
So both as regards the offence charged with and the length of sentence, a degree of caution is required, because these are foreign convictions. And that is why in my submission, that type of provision sits happily within the immigration rules rather than within a statute, giving the additional flexibility thereat.
Why have we got a statement of policy for those coming in, wherever the offence is committed, and rules and statute for offences committed here, but nothing for those already here?
My Lord is entirely right. That is the reason why we are here today. But I say, in the absence of that, we do have a structure which is helpful and which can be applied, and it's the structure derived.
But can you apply as a guide or by analogy or directly the entry clearance to this situation?
The unhelpful answer is, it may depend.
Well, let me put it directly. If we find the tribunal did do that here,
Yes.
was he wrong to do so?
Yes, this will be one of the questions for you to...
Yeah, and are you saying yes, he would be wrong to do so?
No, I would say that given that we don't have the statutory underpinning for persons who are committing offences abroad that we do for domestic ones, the court starts with the open-ended Strasbourg test. But it is also legitimate and appropriate to look at what the Secretary of State has said by way of policy as formulated in the immigration rules, or by way of policy guidance to caseworkers, and take that into account insofar as it sheds helpful light
And
on
does
how
it or doesn't it?
Yes. In a case where an individual has arrived with leave to remain, has an exemplary immigration record over a lengthy period, there would of course be difficulties in applying the entry clearance criteria because the two individuals for Strasbourg purposes are not in an analogous situation. Contrast the situation where you have an individual, and we'll look at SC in a moment, who hasn't arrived with leave to remain, who has never had leave to remain, and who commits offences abroad. Should that individual be in a significantly better position than an individual who applies for entry clearance from abroad? Or does 1.4 give us some help in the public interest as it bears upon that situation? And I say it does, in that context. And Article 8 unhelpfully being
Just go through that again.
Yes.
Sorry.
So, at one end of the spectrum, you have an individual who has an exemplary immigration record, who has stayed in this country for many years, and who has committed an offence abroad. Is that person in an analogous situation to one applying for entry clearance for the first time? Probably not. Contrast the situation of someone who has entered unlawfully, who has never had leave to remain and has committed offences abroad, is it possible to derive guidance as regards the public policy impacting on that situation from SE 1.4?
And on the facts of this case, he entered on a false basis. He said he was Kosovan and he wasn't,
Yes.
but he still got indefinite leave to remain. He doesn't have refugee status.
Yes.
So, in relation to Mr. Gosturani, two questions. Would it be unlawful to apply the approach set out in the entry clearance rules? And secondly, specifically, did the judge go wrong in paragraph 34B?
Yes. Those are the questions which arise.
When you say yes, I understand you saying yes to both. Yes, you can't have regard to it, and yes, the tribunal judge was wrong. But I
I thought you said yes, those are the two issues.
those are the questions.
Those are the two issues which arise. I say
I wasn't asking you to mark my homework.
Yes.
I was asking you to answer the questions posed in the exam. So what are the answers?
It's good to know you got the questions right.
Yeah.
yes. On the issue of whether 1.4 sheds relevant light here, yes, it does. It does because this is an individual in an analogous situation to one who has come in without leave.
Because he came in on a false basis.
Yes. And he's not only that, he has lived that lie and maintained that lie.
20 years, yes.
Yes.
Yep.
And then two, was the judge wrong to draw such assistance as he did from the expression of public policy in paragraph 1.4? No, he was not.
So he did it, but he wasn't wrong, or he didn't do it, and if he did, he wasn't.
What he did in standard Strasbourg and Hesham Ali terms is he commenced with the open-ended article balancing exercise. He brought to bear in that balancing exercise the expressions of public policy made by the Secretary of State, as endorsed by the upper tribunal in SC. And he arrived at a conclusion which was both open to him and entirely in line with the principles derived from the Strasbourg jurisprudence.
So in blunt terms, there was nothing wrong in the judge doing as he actually did do, to say he wouldn't have got in for entry clearance because the government doesn't regard that as appropriate. And for a man like this who's come in on a false basis, that reinforces the view that I should take a stiff
Yes.
line. Is
Yes.
that it?
No, yes, no more.
No more than that.
Okay. Well, where do you want to go next?
I think it may be worth, because it addresses the same points just made by Lord Justice Lewis to me, to SC,
Yes.
because
Do we need to look beyond the passage quoted at 34B in the judgment?
Yes.
We
And
do.
I say, framework of SC was as follows. This was another Albanian national. He was not a foreign criminal for the purposes of paragraphs 398 and 399D, because he had committed the offence he did commit, which is one of murder abroad. He had come in unlawfully, and he had remained unlawfully for a lengthy period of time. And the upper tribunal was called upon to determine a number of things. One of them was still then a live debate as to whether paragraphs 398 and following applied to offences individuals with offences committed abroad. The answer was no, it did not. You'll find that in paragraph 71. Then the next question was, if it does not, what is the appropriate decision-making process to apply? And you'll find that process, paragraph 95, which is the balance sheet approach commended by Lord Thomas and Hesham Ali. First looking at the matters on the respondent side. And 96 is of interest, where the upper tribunal says, in terms, although the public interest in deporting the appellant as a murderer is strong, we accept that the strength of the public interest is not a fixity. And it takes into account that murder is one of the gravest crimes committed in any human society. Considers whether the public interest is diminished by time. It considers factors weighing in favour of the appellant. And it comes to a conclusion, striking the balance of paragraph 114. The outcome of the proportionality balancing exercise is we find firmly in favour of the respondent. The best interests of the appellant minor children are clearly that he should stay living with them in the United Kingdom. The evidence, however, fails by a significant margin to show that it would be unduly harsh on each of them if the appellant were to be deported. The same is to be true of the appellant's wife and the adult children. I think the high point of the criticism of this challenge, which in my reading is made, is that the two words there used, unduly harsh. I think it was being submitted that that is an indicator that the tribunal was applying section 117C by a backroad. My submission, when one reads the decision as a whole, this is not the process that was adopted.
And this judge didn't use those words, he used the words unjustifiably harsh.
Yes.
And justifiably reflects the kind of language you use for Article 8.2. He didn't use the word unduly harsh, unless I've misread the judge.
Yes, no, that is absolutely correct. That means the slope is even steeper as regards this decision under challenge in this appeal than it was in Kokaj. And just to set in...
Well, in fact, the tribunal in this case used the test unjustifiably harsh in paragraph 94, which was quoted by the tribunal.
I mean,
Yeah. Yes, that is.
so, just take. Where do we see SEC 1.4 actually set out?
You're one step ahead of me on that. SE 1.4, you find that in the decision at paragraph 73.
In SC.
In this,
In
yes,
SC.
in SC
73.
71, 72, 73 is where this.
Right. So unjustifiably harsh consequences comes from the exception.
From the exception, and the reason it became material, the reason it was considered material in the open-ended Article 8 balancing exercise was paragraph 83, where the tribunal says, accordingly, leaving aside the safety of the conviction, the appellant's conduct means that he falls squarely within the ambit of SEC 1.4. It would, as Mr. Gullick submitted, be abhorrent for the appellant to gain any advantage over those seeking entry clearance who have committed similar offences by reason of the fact that his presence in the United Kingdom arises only because he entered unlawfully.
So where was it? Where are we reading from there?
Paragraph
83. Yeah, okay.
And you're saying that there's nothing wrong in taking a similar approach. Parliament would be unlikely to have intended that you could stop somebody coming in because he's committed a crime abroad, but you couldn't, subject to other factors, take the view that he ought to go now, having come in on a false basis and done a crime abroad.
Yes. On my second stage of the process, that is taking into account pronouncements of public policy by the Secretary of State. SE 1.4 is a pronunciation of the public policy applying to someone who hasn't gained any lawful foothold in the country, is seeking entry clearance for the first time. And I say that does give some assistance to the Article 8 balancing exercise. That's what the upper tribunal did in SC.
In other words, you can reason by analogy from the statement of public policy in this provision.
On the facts of a particular case. Yes.
Thank you very much. We'll rise now and resume at, 2.
All of us.